Okay, so this is export and import issues. Let me just introduce who we have here. At the end of the table for me is Liz again. You might remember her from the last panel. Hi, Liz. Liz Bryan, Grant Thornton, head of media tax. Next to her, we have Michael Stretton. He is royalties controller. I love that title, royalties controller, at CC Young & Company. I love royalties controller, just as long as there's lots of royalties. Okay, there's Michael. Next to Michael, we have Eamon Chalk. He is a partner at BRIFA, which is an intellectual property, technology, and data protection law firm, and he's going to talk about one of my favorite acronyms, which is GDPR. Ooh. Okay, and next to Michael, last but not least, we have Genevieve Dexter. She is from Serious Lunch. She's the founder and CEO. It's a TV distribution company, currently representing all kinds of things. Horrible Science is the one I know, Art Ninja, various other things. She also wears a couple of hats. So she's an expert in IP exploitation, business growth, executive producer. She's also the CEO of something called iPresent, which is an animation studio focused on children and family IP. Do you have any spare time at all? No. Okay. So this is about export and import issues, and I'm going to start with Genevieve. So we've heard a lot this afternoon about Brexit and how it will, different, no deal. How is there going to be a gap? Depending on what's happening. Can you fill us in on how do you think Brexit is going to affect program distribution and sales with the EU or into the EU? Where do you think that's going to end up? Is it going to be a huge crisis? Is it basically going to be business as usual?
I think as far as I can work out, business as usual.
Mm-hmm.
And I've been trying to do a study of a comparison between an overseas distributor outside of the EU with the UK distributor and talking to them about what their experience is, and so presumably we'll be we'll be WTO at that point, and so we will be outside. So I have a slide on that too.
Oh, good. Do we have the slides? Genevieve's first slide, maybe?
Yeah, Mac.
First we're going to talk about Blonde Ambition? No. What is this? Oh, this is nice. Do this one. Okay, do this one. Look at that. You were born the same
we're separated at birth.
I wish you were the Prime Minister. Sorry. Okay, yes. Okay.
Yeah, Boris and I are separated at birth, but we both share an ambition, although perhaps not going about it in exactly the same way. So on my next slide, I just wanted to run through a short comparison between two independent distributors, my own in London and Bajuba in Canada, and Tatiana, who runs that company. We've been emailing back and forth over the last few days to say, what's your experience?
Mm-hmm.
How do you deal with import, export, withholding tax, and so on and so forth? Withholding tax is probably the most complex area, and I know Liz is going to talk about that later, so I won't venture too much on that, except to say that that is a unilateral bilateral agreements between different countries. So in Australia you have 5% withheld. In France you have 33% withheld, but if you fill in the right forms it's 0%. And in Germany it's 15.872%, but you can claim it all back. So every country has a different way of dealing with it. But we don't really have import-export levies because we're not exporting an object. Even in the days when we were shipping digital beta cans, you send it by FedEx and you put on the docket no commercial value, because you're not selling something. You are giving somebody a license you're giving somebody a license to distribute, to transmit your program for 3 years.
Mm-hmm.
You're not exporting something that's then going to be resold.
Okay.
And now, of course, the transfer is all digital.
But is that going to change? I mean, does she have a more difficult issue in Canada now with that?
No, it doesn't.
It's the same.
She has slightly different withholding tax situations, but otherwise it's the same.
Mm-hmm.
I spoke to Kingston Smith this morning about the VAT and what the impact would be post-Brexit, and they said we just don't know. But currently we don't charge our clients VAT, and we work on the reverse charge rules, so we put our VAT numbers at the top of our invoices, and we don't charge each other. Then I thought, well, what if I'm going to buy a dub? I'm going to have a show dubbed into French in Paris, and they're going to send me an invoice. Are they then going to be sending me a VAT invoice? So
Probably.
well, I phoned up a dubbing company and said, okay, so when you're dubbing something in Paris and you're exporting it to Canada, do you send them a VAT invoice? And he said no, because it's considered services, and so it is deemed that the services are rendered in the country where the services are performed.
Okay.
And so therefore we do not invoice each other for VAT, and that's unlikely to change. The area where we do see a threat is in human resources, and so Layla, who's here today, is my director of sales. She, despite having lived in this country since she was 17, had to apply an 80-page document for right to remain. And it was very complex and very stressful. And during that, you were supposed to itemize every time you had left and re-entered the country and for how long.
God.
And then if she would like to be a British citizen, then she has to pay in excess of £1,400, depending on whether or not you want the welcome pack.
God. Sorry, what's in the welcome pack? A biscuit? I'm sorry, yes.
And that felt very bizarre.
Yes.
And obviously
And also, how do you track that stuff? I mean, I'm not sure I could do that, because we don't get our passports aren't stamped anymore when we go. Anyway, sorry.
It reminded me of when I applied for a Russian travel visa. You have to list every country that you've been to, and when you went and for how long you went for. So that was sort of upsetting, really.
So the employment thing is the big one, you think, is the big difference here?
Yes, I think so, but I wait to hear Liz on the withholding tax issue, because I think she has some interesting things to say.
Okay. Now, do you have another slide, or do you want to
That was it. I've done quite a lot of research, but it's come up with sort of nothing particularly groundbreaking to say.
So Liz, let's go to you immediately and just ask you. Genevieve has talked about withholding tax, and she's talked about VAT, and she's talked a little bit about human resources. What about withholding tax? Do you agree that it's going to basically be?
I think it's due.
Or sorry, do you want Michael to do that?
Defer to Michael, who's.
Sorry, Michael. Okay, so this is when you want to come in and talk.
Yeah,
about this.
yes.
Okay, go ahead.
Yes,
Sorry,
I
Michael.
was in danger of being squeezed out completely.
Sorry.
That one. Yes,
We don't want to squeeze you out, Michael. We would like you to talk. Yes.
With my part of this is to do with royalties and possibly audit afterwards, right at the end of the process when the income is coming through. The main issue with the income will be withholding tax. It's all settled at the moment. If there's a deal, no one expects any kind of change at all. If there isn't, then there are sort of other rates that will apply. But the process is the same. If you're Portugal charges withholding tax 5%, I think, and you can, provided you make a profit, you can offset, and it's an admin thing, a bureaucratic thing. As long as you get the tax certificates at the time you're paid, because I used to work in Brazil, and every time I paid international royalties to Holland, I had to deduct 15%, send that to the government, at which point I'd get a DAF, as it was called, certificate, and that goes along with the payment to say, right, 15% has been withheld, but if you make a profit and you present this certificate, then you won't get taxed again. And so if you're already dealing with people outside the EU, there's just the chance that you might have to do that same process with EU countries.
Okay, so it'll be more, as you say, an administrative, kind of bureaucratic headache.
But certainly not. It won't happen overnight. It won't wake up one morning and suddenly think, oh, I should have got my certificates. So you have plenty of time. I was going to say that we did mention a bit about exchange rates. When the referendum happened, there was an exchange rate effect, which may well happen if we don't have a deal. And as other people have said, that can be a double-edged sword. If your income is in euros, then it could be, as this happened to us in my firm, we look after a lot of bands and they go touring. It's made a big difference, around 20%.
Wow.
So that could be an effect. I was going to just say another thing about...
So there's no way to mitigate that. I mean, unless you can somehow get them to pay you in sterling, that's just going to be the case. There's nothing you can do about that, really.
No, I think I can't see... I'm not sure whether you'd even be able to change the code. Normally your agreement tells you what currency everything's in.
Have to all become hedgers.
Well, we bank in euros, dollars and sterling, and we try to keep those currencies in those currencies. So if we're taking license fees in dollars and we're reporting to Japan in dollars, then we will pay it from the dollar account. We try to avoid becoming currency traders, because we're not, and so we minimise the risk to our producers by doing that.
Seems like a good idea.
But other than that, the weakness of the pound has been very good for us and for our clients.
Yeah.
And just as a last word, I think on the audit side, even right at the very end of the whole production business, that wouldn't be affected by anything because it's the contract between you and the distributor. Audit rights wouldn't be affected because they're only governed by that agreement, and payments resulting from it are subject to everything that's come before, so all quite...
Pretty much steady state in terms of that. Okay.
I'd say so.
One of the things that Genevieve also brought up was VAT. Now, is that something you can talk about, or do we want to go to Liz to talk about that?
More... Lynn's got more to say, even
or do you want to bring up...
Shall we just have a quick look at the slides?
Sure, so you have some slides.
This just illustrates what Michael was talking about right at the beginning. So at the moment, the UK is a member and has the benefit of what's called the EU Interests and Royalties Directive, which broadly means that payments that are made between countries, companies in country, are subject to beneficial rates because we're all within the EU. And I'm really only going to talk about in the context of a no-deal scenario. So in a no-deal scenario where we leave, we suddenly lose the benefit and we fall outside that directive. So what does that mean in practice? Well, it's not all bad news. What that broadly means is if you're receiving income from a particular territory, rather than having a beneficial rate of 0 under the directive as it currently stands, that country will look at its domestic withholding tax rate and say, well, what should we be deducting from you as a payee in the UK? But that's not the final point. What they'll actually do is look to see whether there is a double taxation agreement in place between the UK and that country, and they'll look to see what that agreement says and tell it about the amount of tax that needs to be deducted. So the answer is, at the moment, I'm following Michael's point, at the moment you might be bearing 0 rate on income coming from EU territories. But in the future, there might be a rate applicable because our treaty doesn't reduce it to 0. And so there are our roadmap here. We've tried to do red, orange and green in terms of who's affected. You can ignore pretty much the dividends and interest columns. What we're really interested in this room is royalties. So this would be where you have a direct, where you've negotiated your own deal direct for income from broadcaster in another European territory. This is unlikely to apply if you've contracted through a distributor. I want to check with the distributors in the room actually, because where a distributor is actually marketing for you, they have the rights and they're the ones that will be suffering this rate, not you directly. But if you've brokered your own deal and you've got income coming from, say, Germany or Italy, instead of making the assumption that you'll be able to have that gross and free and clear of any withholding tax, you'll now need to look at the table and say, what does the rate say under the table, and have I got an immediate withholding tax cost that gets deducted from my payment rather than zero? So there are, and it's not a terrible answer. You'll see there's lots of green, which is good news. There are odd territories where there will be a rate applicable in the future where there isn't currently. So you can see the ones that are orange.
So basically you need to avoid the Czech Republic, it looks like.
if you flip onto the next slide, because this is obviously I think we've done the other. You'll see there's a few on there. So you'll see there's a few 5%ers creeping in, 5%. Where previously you would have had 0%, but that will be the cash impact to you. That doesn't mean it'll be the overall cost to you, because you may be able to offset that withholding tax. But it means rather than getting 100% payment, you'll have that 5% deducted at the time of payment.
Right. So this is if we are completely out, right?
This is a no-deal scenario. So A hopefully won't be in that. And good news, there's lots of green on the slide.
That's true.
In that end column.
And then I think there was another slide that was important.
There is another slide which that just talks about applying the EU directive and the circumstances in which we will still be able to apply that. So that's the good news piece, because that's where hopefully we will be in terms of continuing participation in that.
So basically this looks like...
the two previous slides were the worst case scenario, and even those have got lots of green on them. Mm-hmm. So my main message is it shouldn't have a major impact, and actually if you've sold your rights, it's the distributor will actually be bearing this cost and not you directly. Mm-hmm. There'll be a question about looking at the fine detail of your distribution agreement as to who actually bears that withholding tax cost.
Are you a distributor? No.
Yes.
You are. So how do you feel about this?
Well, what we tend to do is we tend to share the benefit with our producers. So let's say we do a deal. Let's say we do a deal in Germany for £100,000 or euros, and then let's say our commission is 30%. Then we bear the cost of the 30% of the withholding tax, and we pass 70% of the benefit onto the producer, and they can then reclaim it from their corporation tax. There are a lot of distributors that take the sole benefit. So like Liz says, it is important to look at the fine print on your distribution contract.
Exactly right. Exactly. Always look at the fine print, right? So Liz, is there anything else you want to add about this? And we've kind of covered, I think we've covered VAT, withholding and all that.
I think we've covered VAT. Mm-hmm. I mean, again, hopefully in a deal scenario, the VAT will obviously all form part of the movement of goods changes and how they pan out, so hopefully they won't be too bad. If it was a no-deal scenario, there will be changes, there will be impact for UK producers selling into Europe or importing goods or incurring VAT in Europe. Mm-hmm. Doesn't mean to say that again ends up being an absolute cost. It just means it's a bit more fiddly and there's a bit more paperwork and process in order to get that VAT back.
I always worry about more paperwork and administrative stuff, particularly small companies. They're creative companies. It's just one of those things. I'm a business journalist, and over the years, I can't tell you how many times companies that have marvelous creativity and they don't have that back office support, and they get in trouble. And it's such a shame. So I know it says to you, it's just more administrative stuff for small companies. This is a huge headache. Huge headache.
And that's only no deal, so hopefully they won't be in that position.
Hopefully there won't be no deal. There was another thing about that Genevieve brought up, and I don't know if this is the right time to talk about it, the human resources bit. I think we're going to talk a little bit more about human resources in the next panel, but is there anything else that you guys want to say about human resources right now? She was talking about, it's the pressure on the people, if you see what I mean, with all this. Is there anything that you all can add to that, or not so much? Not so much, they say. Okay, great. So we'll push that to the next panel. So Eamon, you haven't said anything yet, so we're going to come to you. So GDPR, one of my favorite topics, the General Data Protection Regulation. Tell us what happens with a deal or with a no deal. What's your view on how, where we're going to be with data? Because data obviously is pretty important.
Well, when you said GDPR earlier, I saw the collective light go out behind the eyes of all these beautiful faces in front of me. So
Yeah.
it might be worth be worth saying what GDPR actually is. It stands for General Data Protection Regulation, and very basically, it's a European-wide law that was introduced in 2018 to regulate and to protect the rights of citizens when their personal data or personal information is handled and when it's transferred. And so to achieve that, the law introduced a number of rights that were afforded to data subjects, to individuals, and it also imposed a number of obligations that were imposed on the people who handle data controllers and data processors. And one of those really significant obligations that are imposed on handlers for the purposes of this discussion is that if you move data from the EEA to a country outside the EEA, and they call them third countries, then there are additional conditions, restrictions, safeguards that have to be put in place to ensure that the level of protection that you would have had if your data was processed within the EEA will continue to apply when it's moved outside. So that's the kind of context and starting point. That's just not important, and that's definitely not important.
No, you're very important, yes.
So data protection, in a deal scenario, it's actually not that complicated. Because if we have a deal, we have a withdrawal agreement, and if we have a withdrawal agreement, we have the benefit of a transition period. And if we have a transition period, EU law, including the GDPR, will continue to apply until 2020. So if you're moving data from the EEA to the UK will be treated as if it was still within the EEA. So there's no additional restrictions, no additional conditions. If you're somebody who's moving personal data in the course of your business, there's nothing else that you have to do. And then during that transition period, one of the provisions in the withdrawal agreement is that the EC, the European Commission, has said that they will commence this process of assessing the UK's data protection infrastructure with a view to granting an adequacy decision. And an adequacy decision is basically a decision of the European Commission given in favour of a non-EEA country which says we're broadly satisfied that your data protection regime is adequate, or at least that you afford comparable protection as data subjects would have within the EEA, and therefore if data is transferred from the EEA to your country, we won't require any additional conditions, no additional restrictions, no additional safeguards. So that's how you deal with, and as I said on the fourth point, the ambition is that adequacy decision would be done and dusted by the...
And who makes that? Who makes the adequacy decision?
The European Commission.
The European Commission makes it.
So there's a formal process by which a country that's not in the EEA applies. Okay. They look at the rule of law, they look at infrastructure, they look at all these various different points in the process and decide, yeah, we're satisfied.
So here's a lateral question. So, you know Mark Zuckerberg?
Yes.
Runs a little company called Facebook. Right. So when Facebook started looking at GDPR, they went, oh, this is interesting. And they actually applied the GDPR standards globally because they thought, we don't want to get into trying to figure out, in fact, they thought that probably the EU's GDPR law was pretty good.
Yeah.
So do you think that's going to start to happen, that we're just going to take it as the standard even if we leave?
Yeah, well, I mean, the law that currently applies in the UK is the GDPR. So I think when we leave, broadly speaking...
Because we are part of the EU.
Exactly, yeah. So I think when we leave, immediately following the exit, with or without a deal, the law will be the same. The more interesting question, I think, is as you go on, 10 years down the road, 20 years down the road, you might say, well, in the UK, now we have control over our laws, and we think actually commercially GDPR is overly restrictive. So we might decide to carve out some exceptions. We might make it easier for people to move data.
Well, this is the way the US is now.
Well, this is the way, and that's why with the...
I think that's the wrong decision, by the way. But anyway, yes.
I think you're probably right, and I think for companies like Facebook, it's just easier if you have companies all over the world and you have to have a process in place, a global piece of machinery that is able to cope with data moving. Yeah. You don't want to have to get into that machinery and say, well, is this going to a country inside the EEA or outside the EEA?
Yeah, but keep in mind, this is a business, it's a global business. The AV sector, help me out here, Genevieve, is a global business. We are selling to global platforms. We are transferring data about what customers are doing on global platforms all over. I mean, I think that the argument holds.
Yeah, no, I think you're probably right. I think for global companies, you choose the strictest regime and you say, let's comply with that. And then you can comfortably go and say, if we've complied with that strictest regime, we're going to be covered everywhere else as well. So yeah, I think that's right.
Okay, now do you have another slide? or
Yeah,
is
so
that-
the next one then is
okay.
what happens if we don't have a deal.
Yep.
If we don't have a deal, it's slightly more complicated because then the legislative framework actually does have to change. So currently in the UK, there's three pieces of legislation that apply: the GDPR, which is a European law, the Data Protection Act, which is a UK piece of primary legislation, and the Privacy and Electronic Communications Regulation, which is a UK piece of secondary legislation.
Yep.
If we leave without a deal, the day after we leave, GDPR ceases to apply to UK controllers, and GDPR UK is automatically introduced, which is essentially almost a carbon copy of GDPR with minor amendments to make it kind of UK specific. So the law will still be there, the framework will still be there. The big issue is with data transfers, because now we're in a situation where we don't have the withdrawal agreement, which means we don't have a transition period.
Right, no transition.
We still don't have this all-important adequacy decision where the European Commission has said, yeah, we're cool with data going to the UK. So you have this gap of, it could be 12 months, it could be a lot longer than 12 months.
Yeah.
And you say, okay, now these additional conditions and additional restrictions and safeguards that apply to countries outside the EEA who don't have an adequacy decision, they now do apply in the UK. And Regulation 46 and 47 of the GDPR provide for the various different things that you can do to ensure that level of protection outside the EEA. For most companies, for the average company, what you're going to want to do in the short term is look at your contracts or look at your arrangements that facilitate the flow of data from the EEA to the UK and include these standard contractual clauses, which the European Commission has approved and basically said if you have a data sharing agreement or a data processing agreement and you've included these clauses which guarantee the same level of protection that you would have in the EU, then we're satisfied that you've taken that extra step, those additional conditions to ensure protection.
Okay, so basically people have to look at all their contracts because this wouldn't necessarily be in contracts at all.
No, it wouldn't be, and it's it's not, if you have
Another administrative nightmare.
Another administrative nightmare, yeah. And I think unlike, and I'll talk about this when I come to the IP bit as well, but unlike your tax returns or your company filings or lots of other administrative things that small companies have to do, somebody's going to give you a poke at some point. Someone's going to send you an email, there's going to be some kind of a notification. This is the kind of thing that nobody's going to poke you about.
Yeah.
And you're only going to find out about it when somebody makes there's a data breach, somebody makes a complaint to the ICO or a European Supervisory Authority, and then somebody comes knocking and says, I want to have a look at your data protection processes.
Okay.
So that's the kind of big thing that you need to look at is kind of look at your business, look at where you're sending this data, map it all out, and say what contracts or arrangements are in place for that data flow, and what amendments do I need to make to that. In the longer term, even if we do leave without a deal, we're still going to make that application process. We're still in all likelihood going to get that adequacy decision.
Right.
But it's about what happens in
the gap.
year or 2 years in between. And I should say as well, you see there's two little points there, bullet point 2 and bullet point 3 in the second section. The UK Information Commissioner's Office and the UK government have said, if you're sending personal data from the UK to the EEA, we're fine with that. We're satisfied that our current data protection law is based on the GDPR law. So if it goes out, we're not going to apply any additional restrictions. But if it's the other way around, the European Commission hasn't exercised us the same courtesy. So they're going to say, no, we're going to do a proper assessment as we would with any other third country, and only after you've had this adequacy decision will we allow you to do these unrestricted data flows.
Genevieve, is this making your heart beat faster?
Well, I'm only thinking two things. Is I can't think where in what scenario, either as a producer or as a distributor, we would be holding that data. I can understand as a broadcaster, or having a platform, but I'm not quite sure how, as a producer or a business-to-business distributor, I would have this data, except if we dropped out of the EEA regulations, then it might mean a potential return of interest-based advertising. So you'll know recently YouTube were fined for collecting data on children's interests from YouTube, and they used to hold auctions all the time of advertising to companies on interest based. So if you were a manufacturer of footballs, you could do an auction of advertising space on YouTube to a
Football buyers or something.
Yeah, manufacturer, whatever. And that's now been stopped. So that's meant a huge loss of revenue from YouTube advertising for independent producers and distributors. And YouTube is saying that they're going to ramp up an old school style advertising team, to go and try and sell this advertising. But that would be a case perhaps where we're able to sort of stop this sort of perpetual exodus of any revenue coming into the children's business, because each time it's removed advertising around
high fat and salt, sugar, whatever it is, junk food.
No junk food advertising. That ripped a huge swathe of revenue out. We've just had another huge swathe ripped out from the YouTube revenues, which hasn't started to hit yet.
Yeah.
But other than that, I can't think of a scenario where I think as a platform you'd be collecting data. But I can't see a scenario where as a producer.
How about personal data from, let's say, I'm making this up now, she has a French office. Would that be?
Yeah, I mean, that's what I was thinking as well. And to your point about the HR, generally just the HR consideration, for larger companies who are just dealing with employees or freelancers or suppliers, if you engage people, if your business is operating on an international structure and you have to have information about all of these people just to be able to kind of work with them, you're going to have their name, their email address, their phone number, their insurance details, their pension details, suddenly you have lots of data. And somewhere in the UK, you've collected that data potentially from people outside the UK, if they're in France or Germany or wherever they are, but the database is in the UK.
Right.
And there is some contract somewhere that regulates why you have that data, whether it's a supply agreement or a distribution agreement, employment agreement.
So it's not just customer data, it's really HR data. It's employment or freelancers that you're working with data. Or
I probably should have said right at the top of the talk as well, personal data is any data that identifies a living individual. So an email address, a phone number, your Facebook ID, your device ID, a photograph that identifies you. Any of that piece of data that is recorded somewhere is quote unquote processing and engages the legislation, and a lot of these obligations apply. And this is the reason that everybody was jumping up and down about GDPR in May 2018, because you were seeing all of these kind of news stories come out in all newspapers, and there was a lot of misinformation as well. People were saying you were going to have to get consent every time you had a conversation with someone, which isn't the case either. But I think that's why, to my kind of Brexit, well, there's Brexit specific actions, which is look at processing activities, look at privacy notices, look at the various different data protection kind of things that you have in place. But my non-specific my non-specific Brexit recommendations are almost more important, because I think in a time of uncertainty and in a time of flux, usually government entities, when laws change, they take a very, very common sense approach, and they say we're going to give people a chance to get their house in order. And by the way, that's exactly what happened when GDPR was introduced in 2018. There was essentially an unofficial grace period. Thousands of companies up and down the country were not compliant and are still not compliant. But the ICO has kind of said, as long as people are doing as much as they can do and they're being reasonable and they're doing sensible things, we're not going to take strict enforcement action. And I think it's the same now. I think that if we do leave, particularly without a deal, the regulators in the UK and the regulators in Europe are going to appreciate the context in which this has happened, and as long as people are complying with the existing law, I think you're going to be in a better position than you would be if you're not even complying with the law that's now 2 years old.
Okay.
And so these 5 points are what the state of the law currently is. You have to have certain internal documents. You have to have organizational and technical measures in place to ensure that you're handling data properly. You have to have external privacy policies for your websites and for particular projects. You have to report breaches, and you have to have documents with data controllers and processors.
Okay, I'm going to just be, because I can do it. I don't know a lot of these acronyms. What's a DPIA? What's that? Sorry.
A DPIA is a data protection impact assessment, which
of course it is.
If you do a project if you're running a project which carries a particularly high data protection risk, you have to set out what you're doing, why you're doing it, how you're processing the data, and it's essentially an internal document that you can show to the ICO if they ever ask
So you need to have
for
that.
your behaviour. Yeah.
Okay, and then LIA?
An LIA is a legitimate interest assessment.
Of course.
One of the legal bases for processing, and the one that people know the most, is for processing personal data, is consent. You can process someone's personal data if they allow you to.
To do it, right.
But very, very often, particularly in, commercially, people are dealing with big data sets. It's just not feasible to get consent from everyone.
Yeah.
So you say you can process someone's personal data if it's in your if you have a legitimate business interest that doesn't outweigh or prejudice the individual's rights. But you have to set all that out in a document and kind of account for your behaviour again.
Okay, DPO?
Data Protection Officer.
Of course it is. I have one of those in my company, I'm kidding.
Yeah, and an SAR is a subject access request.
Subject access request.
If a data subject asks you what data you hold about them,
then you'd be able to say.
Respond, yeah.
So if I work for Genevieve and I say, well, what are you holding on me? She needs to be able to tell me what it is.
Yeah.
Okay, got it. Right, keep calm and check your data.
Yeah.
Good. Well, let's try to keep calm. Talk to me about copyrights and patents. Do we want to talk about that a little bit?
Yeah. So I won't move the slide yet because I don't want to take attention away from.
Yeah. Talk first and then put the slide.
Yeah.
Particularly if it's got a nice little thing like keep calm.
Yeah, exactly. You
and
can
check
direct
your
attention
copyright.
there. Continue to keep calm. So, intellectual property, as lots of people will know, is a huge subject. You could talk about it endlessly for hours. And that's the first point. The second point is people very often will use intellectual property interchangeably with copyright, patents, trademarks, designs, lots of other types of IP. But the truth is that IP, or intellectual property, is the umbrella term, and there are individual intellectual property rights that sit underneath that, and they're all regulated separately. They all have different rules and they all do different things.
Okay.
So for the purposes of this talk, I've divided them down into the 4 big statutory IP rights, which are copyright, patents, trademarks, and designs. Very, very quickly, copyright protects creative works, so literature, art, film, music, software, all protected by copyright. Patents protect inventions, trademarks protect brands, and designs protect designs. It could be it can be a 3D design like the shape of a chair, or it could be a 2D design like the pattern on the front of a coat. And then within that, you can subdivide them again into 2 separate rights. The first are copyright and patents, and the reason I separate out those 2 rights is because they're the least problematic from a Brexit perspective. And the reason for that is that whilst you can of course have international copyright protection in the sense that if you have copyright in the UK, you can enforce it against an infringer in another country, and similarly if you have a patent in the UK, you can get a patent in another country. But all of those rights arise on a country-by-country basis, and the international recognition and enforcement of those rights is achieved through international treaties, laws,
not EU treaties.
which have nothing to do with the EU. That's
Right,
the
so it's kind of
significant
above, it's almost the opposite.
Precisely, yeah. So we get international copyright recognition under the Berne Convention, and the UK has membership of the Berne Convention completely independent of its EU membership.
Great.
Similarly, EPC stands for European Patent Convention, and PCT stands for Patent Cooperation Treaty. Those are 2 instruments that facilitate international patent applications and international patent protection. Again, have nothing to do with the European Union. So even though the European Patent Convention is a European instrument, it's not a European Union instrument. And
yes,
so for
a misnomer in terms of its title. Yes, go ahead.
Exactly, yeah. And so for the purposes of Brexit, whether we leave with a deal or without a deal, that will not change. We will still be able to have international copyright and patent protection. We will still be able to enforce it internationally. What will change potentially over time is that EU case law on patent cases, on copyright cases, will no longer be applicable in the UK, and we already see kind of culturally differences in the way that judges approach certain kind of discrete points, and it's to be expected, I think, that will diverge more and more because the UK courts aren't going to be required to follow EU law and EU principles anymore, so they might decide, well, EU law says such and such a new type of work is protectable in this way. We actually take a more restrictive view of copyright. We don't think this new type of work should be protectable. And there have been all sorts of cases where people have said, well, should a tattoo be protectable, for example? And there's an argument to be had about that because it is an artistic work, but it's not permanent. It's not fixed in the same way that something. And there have been cases about you've protection for dramatic works, but yoga moves can't be protected by copyright, for example.
Oh, that's good to know. Yoga moves cannot be protected.
Can we make champagne?
Can you make champagne? You mean for the geographical indicators point?
Yeah.
It's a trademark question. We can't because again it's governed by the national laws, and geographical indicators are treated separately as well. Someone heard the name champagne and immediately went for the nearest pub at King's Cross.
No champagne for Siri today.
So yeah, the takeaway point for copyright and patents is
I think that one actually might be quite important. That this divergence thing in the future, because there's always new stuff that's coming. I mean, if you think about it, who thought we were going to have voice activated gaming and stuff? I mean, this is there's all kinds of things that are going to be coming down the pike. Or, what kind of copyright protection will there be on, I don't know, the new VR game or whatever it is. So anyway,
and there's already huge differences between, for example, the way we think about copyright in Europe generally and the way you think about copyright in the US. The way patents are dealt with in the US are completely different. You can get protection for software quite easily.
I mean, do you think that we're going to go down the road, this also was the last panel as well, that basically the UK will become more US-like if we have a no Brexit deal and just disappear from Europe? Because I know there are certain components of the current party in power that would like to see that.
Yeah, I mean, I think it's an interesting question. I don't know the answer, but you can see why, even where we're in the western extremity of Europe, our closest neighbour to the west, excluding Ireland, the best country in the world, is the US. And so, you can see why there's lots
and where we're all going to have offices set up so we can remain in the EU in some way.
Yes,
go ahead,
it's
sorry.
very important.
It's the Republic.
But yeah, I mean, there has always been an impetus to facilitate commerce between Europe and the US, and you see things like Privacy Shield to make the trade of data as easy as possible. You have things like international treaties that facilitate all of that. So yeah, I mean, I think traditionally the European approach has been more restrictive than the UK approach in certain respects. And so yeah, you can see that if the UK sees an opportunity to open itself up to aligning itself with the US, there may be something in that.
Yeah. So that's your last slide, right?
That's the last slide on copyright and patents, and then the other two kind of remaining big IP rights are the unitary rights, and the reason that they're significant is that they are EU-wide. So if you get an EU trademark, it is enforceable in all 27 member states. If you get an EU registered design, it's enforceable in all 27 member states. If we have a deal, all of those rights will continue to be enforceable in the UK as if the UK was in the EU, so very, very similar to the GDPR position. If we don't have a deal, all of your existing European Union trademarks and designs will be enforceable in the 27 only, and you will get automatically and for free a UK trademark, which is a clone, an identical copy of the EU trademark you had, and that one will be enforceable in the UK only.
In the UK only?
In the UK only. And that's for trademarks that have already been granted. For pending EU applications, they will be dropped, and you will have 9 months then to apply for the same trademark in the UK again.
And what do you do for protecting your trademarks outside of the EU and the UK? I don't see that in no deal. We'd have to just make a new trademark. We'd have to get a new UK trademark, and then that would be enforceable.
So, you're saying if you don't have a trademark at all already and you want to protect it in the UK, you'll apply to the UK.
Apply to the UK. Okay.
Yeah, directly. Yeah, as lots of people have already started to do. Yeah, and then I just had a couple of kind of considerations there. So if you have an existing EU trademark, you don't have to do anything because you're automatically going to get a new UK trademark, and it's going to be for free. If you have a pending application and it's not going to be registered before the 31st of October or whenever we're about to leave, you're going to have to refile that. It's going to be thrown out. You're going to have to refile it again. If you're filing a new application, it's unlikely now that it's going to be registered by the time we get there. So you should, to your point, you need to file in the UK and you
as well as
in the EU.
Because who knows, there might be extension, there might not be. Just file in both.
You just don't know what way it's going to go. Independent UK registrations are even more important now. If previously if you went to someone and said, let's kind of look at your trademark portfolio and kind of cancel the things that we don't need, we don't want double protection. So people might have said, well, let the UK right lapse because you're going to have protection by virtue of the EU one anyway.
Yeah.
You don't do that anymore.
No.
Your UK rights are really important.
Okay.
And the other point is maintain use of your trademark in the UK and the EU. Separately. Because lots of companies will have had an EU trademark because it's value for money, but they've only ever traded in the UK. The problem now is that if you've only ever traded in the UK but you have the EU trademark, it's going to become vulnerable to cancellation for non-use after a while.
Because you haven't used it in the UK.
Because you haven't used it, yeah. So you need to either kind of see, to your point, if you have an international business and you're licensing brands or licensing merchandise, is it being used in the EU? And if it's not, think about someone you can license it to. So that you're maintaining use and maintaining.
That's an interesting one.
It's not.
I mean, if you're looking at an IP library, I mean, a lot of them might not be used in the UK.
Yeah, I know in trademarks in China, we just wait if it's not available, we just wait for non-use and then we take it.
Yeah.
Yeah.
But it because it's Chinese pictograms. You see, most of those pictograms will occur in other people's trademarks.
I see.
It's a difference, a big difference. But yeah, we just wait for non-use and then take it back.
Take it back.
But it's an interesting point that you could just license it to anybody, I suppose, just to maintain.
Just to maintain it.
Use of it, yeah, absolutely.
Yeah. Okay, and that's.
I had a few other kind of slightly long-term considerations, but in view of the time, you might want to go to questions.
Mm-hmm. Okay. Oh, the other stuff was about what? It was about.
The other stuff was just kind of longer-term considerations around kind of taking advice, thinking about licenses. It's more kind of specialist kind of things, and maybe some of it will be drawn out by the questions.
Okay. Well, let's see if there are any questions from the audience up to this point. If we have time, we'll. So, does anyone have any questions? We've had a pretty deep dive into some of this stuff. But does anyone have any questions about this? I'm going to cough again, audio desk, sorry. There we go.
No?
No questions at all, huh? Oh, come on. Stuart, any questions? No. No, he's saying, no, I'm not asking a question. Where's Tim? My producer for this session. You do have a question. Do you have a question? No?
I think no, thank you, all of you. But from my point of view, what's the importance of the data protection side? I don't know how many of us in this room realise the importance of it, but it's really just the explicit nature of what is required in terms of the context of what data is. So I thank you for that. So if I've got a small consultancy, if any data I hold for anyone that I deal with or in terms of my staff, that I have to protect that. Is that?
Well, as a starting point, you need to know what it is.
What it is. What have you got? What are you holding? Yeah.
And I think.
And where are you holding it?
Yeah, precisely. Yeah. And I think for small businesses in particular, when we kind of cast our minds back to 2018, and we were starting to see headlines about data protection. What, are you kidding me? And businesses were kind of saying, actually, I have no earthly idea what data
I've got here. Right.
You have to go home and sit down at the kitchen table and say, okay, so I have employees, and I have that guy who designed my website, and somebody designed my logo, and then I sell to people online, and I sell to people in my bricks and mortar store, and suddenly you say, actually, I have maybe 10 categories of, and the people who receive my newsletter, people often say, I'm a really simple e-commerce business, I don't have any data. I say, do you have a newsletter? Yes, you do. You have somewhere, data. You have an Excel spreadsheet with a list of email addresses, that's personal data.
Right.
And I think the starting point is kind of getting to grips with what you have, ideally taking some advice on it, and it might actually be a lot simpler than you think it is to just put your privacy notice up, have your internal record, and at least then psychologically you say that's boxed off, I've done that now.
Yeah. And I think this is going to become even more important because if you look at what I'm seeing is what I call the evolution of the independent production company, in that they are starting to become their own distributors in some cases. I mean, if you look at something like Little Dot Studios, which is a subset of All3Media, they're producing channels on YouTube, right? They're collecting all kinds of data, for God's sake, from all over the place, which they're holding, I guess, in Shoreditch where they are. So, you don't even are even aware of some of the data you're starting to get involved with. So I think as the industry, as companies sort of evolve and we try to figure out how where we're distributing stuff, how we're licensing things, where our brands are going, it's going to become even more important to keep track of your data.
That's perfect. Thank you.
Anything else? No? All right, well, I thought that was really interesting. I learned a lot. Thank you very much.